The Declaration of Independence sets a benchmark for thinking about liberty in the United States in our history. And it says, all men are created equal. Now, at the time those words were written, it was thought of as a path-breaking concept that noblemen and commoners were equal, that rich men and farmers would be equal. But women and children were not included in that concept of equality. In fact, women and children were considered to be, by nature, not equal, not capable of participating in the civic life of the country. And we've seen those kinds of discriminations erode over time. Racial discrimination was entrenched in the Constitution. And it took a civil war in order to cleanse the American political life of that very clear injustice towards people because of their race. The suffrage movement labored long and hard to achieve equality for women, who were not given the vote even after the Civil War, when the Civil War amendments were passed that gave the vote to people of African descent. Women were not included, and it took a long battle to include women in that franchise. The legal system is now attempting to respond to emerging concepts of children's rights. And what we're seeing is an attempt to engage in law reform that will create mechanisms or strengthen mechanisms to protect children from what are clearly very severe harms. The numbers of children who are permanently injured by violence from their caregivers is unacceptably high. So the legal system has to find some way to respond by creating mechanisms and rules that will prevent violence against children. Now, obviously the first step is to make such violence visible. I think we've taken that step by creating reporting statutes, mandatory reporting statutes. Doctors, teachers, many other people who work with children are required to report instances of violence against children. So in a sense, we've made that first step of taking violence out of the closet and making it visible. Now we're challenged with how to take the next steps of not only making it visible, but of responding in ways that protect the authority and power of parents to raise their children. And parents are the people we trust and rely on to raise every new generation of children. How do we protect the parents' authority and yet stop this epidemic? I shouldn't use the term epidemic. How do we protect parents' authority and yet prevent abuse of that authority in a way that causes severe harm to children? Now that's the challenge before us at this time. As a legal scholar, it seems clear to me that we must strengthen the laws that protect children and above all make clear the basis for parental powers, that parents' powers have to be conceptualized and treated as a matter of trust that we place in parents to act in the best interests of children. They're not an absolute right. No one has a right to beat his or her child. This has to be a concept that we bury along with the concepts of slavery and of discrimination against women. It can no longer be a respectable way to think about parents' power. I believe that what we're seeing now is the most recent stage in progression, where at first we found it difficult to accept public laws relating to children's education. Now the new battleground is violence against children and corporal punishment. For example, when does corporal punishment go beyond that which is appropriate for a parent to use and become a form of criminally prosecuted or civilly prosecuted child abuse? This is now the cutting edge. But the same kinds of objections were at one time raised against laws prohibiting child labor and requiring children to attend school. The legal response, what we have down on paper in our statute books, in the written laws, can only go so far. We can only truly deal with violence against children when all of the players in the system, judges, lawyers, professionals who work with children, understand the importance of accepting and acknowledging that the violence is real and that it is wrong,